Thank you.
Good morning, Mr. Marshall.
Good morning, Your Honor. Thank you very much. John Marshall for the Bar Council. This is a bar discipline case, and the question presented for the court this morning is the appropriate discipline for a lawyer who converted clients' funds in part to buy illegal drugs for himself and has not yet made full restitution to the client. Bar Counsel's position is that disbarment is required in this case, and we're asking you to reverse the order of indefinite suspension ordered by the single justice. First and foremost, let me point out that the respondent's failure to make full restitution to the client in this case should be determinative of the sanction. The record shows that after the respondent misused the client's funds and the dust cleared, he owed the client $6,600, and that was known by the end of 2004. The misuse had taken place in mid-2002. In early 2005, after this came to light, the respondent paid $3,000 to the client and agreed at that point to pay the rest over time.
Because he brought it to light, isn't
yes,
it so?
It came to light in probate court proceedings in December, in late 2004. He then self-reported. Yes, that is correct, Your Honor. And at that time, he agreed with the client's new counsel to make payments over time, and he has not done so. And he testified at the hearing in this case in 2008 that he was and always had been ready, willing, and able to make full restitution. So there's no explanation, no excuse for the failure to make that full restitution, and that should be a significant factor in this case. As you know, the board and the single justice recommended an indefinite suspension based upon the board's conclusion that the respondent's intentional misuse of his client's funds was caused by his drug addiction, his addiction to the drug of cocaine. Our position is that that conclusion by the board is not supported by the record and should not be relied upon by this court. Under Schofer, the respondent had a heavy burden to show reasons why the presumptive sanctions in this case should not apply.
But doesn't Schofer say it's either indefinite suspension or disbarment? And aren't they both the presumptive sentence?
The dissent case, Your Honor, actually says that in an intentional misuse case where the lawyer has not made full restitution, the presumptive sanction is disbarment. So we believe that that is definitely what Schofer said at the time. However, there's been a stream of cases both before and after Schofer that have dealt with the question of restitution, and there's very strong precedent that without full restitution, disbarment results, and the dissent case has essentially acknowledged that that's the presumptive sanction.
Should this case come under our new pilot program procedure?
No.
Why not?
You're talking about appeals to the full bench,
Yes.
Your Honor?
Yeah.
The appeal was filed before that was adopted, before the effective date of the adoption of that
Okay.
program, I believe.
Okay.
If it had been after, yes, it definitely would have been. We did not follow that, and I believe the reason was because this appeal predated the effective date of the program. The record in this case does not support a finding consistent with the respondent's heavy burden. The question was whether the respondent's intentional misuse in mid-2002 was caused by his drug addiction. There was very little direct evidence of the respondent's condition during that time. He did testify to a certain extent about his use of drugs during that time, but the hearing committee found that he was what they called a high-functioning drug user all the way from the late 90s into 2004, at which point he began using cocaine daily. They also found that in 2002, when he was misusing his client's funds, he was attending AA meetings periodically, and he was actively conducting a law practice in domestic relations and criminal law. Based upon the facts as found and the evidence in the case, there was no basis for a conclusion that the respondent in mid-2002 was suffering from a disability that caused him to misuse clients' funds. There was no suggestion that he was unable to control his conduct, no suggestion that he didn't know right from wrong. There was no suggestion.
Well, I mean, I don't know whether he could or couldn't control his conduct, but I mean, surely it's the second thing, no showing that he didn't know right from wrong, but drug addiction, I'm not sure that we should just jump over the drug addiction. You can't control your conduct, meaning he couldn't control his addiction?
No, that he couldn't control his daily activities. He couldn't
Okay,
control
that's different.
the fact
That's
that he
different.
couldn't
That's
control
different. Okay.
taking money out of his from his clients' funds to buy drugs. There was no suggestion that that happened because of a lack of control over his access to funds. There was no showing of a diminished capacity or lack of cognitive abilities. The hearing committee didn't, in fact, rely upon the drug addiction in recommending mitigation. The hearing committee recommended mitigation based upon the recovery. The board, however, went further than that, and the board, however, basically found a connection between the drug abuse and the misuse by simply saying substance abuse causes misconduct by grinding down its victims' values. However much that statement may have general applicability, what the board was doing in this case was essentially creating a presumption. They were saying if you're a drug abuser or if you're an alcoholic and you misuse funds, there's a presumptive causal connection because that's what drug abuse does. That's what alcoholism does. That finding was contrary to this court's decisions in the Labassi case, the Luongo case, the Johnson cases that are cited in the brief, all of which acknowledged at some level that the respondent had a disability, but also acknowledged that the respondent had not proven that the disability caused the misconduct. The Gustafson case, which we cited in the brief, is very helpful and we believe most closely related to this case. In that case, a single justice heard evidence that the respondent's misuse had happened at a time when he was drinking heavily, and the the single justice did acknowledge that he could understand that the alcoholism might have contributed or played a role in some way in the misuse, but the judge stopped short of finding a connection because he said that the respondent had not proven that but for the alcoholism, the thefts would not have taken place. That's pretty much exactly the case we have here. The hearing committee said that the drug use contributed to some extent. Ultimately, the board used that word contributed. There's no evidence sufficient to support a finding of causation. Keep in mind that causation is what the Schofer case asks for. Causation is what the ABA standards cited in the brief are asked for. It shouldn't be enough to show some contribution because a showing of some contribution leaves open the possibility that the thefts would have taken place even if that contributing factor did not exist. And if that would be the case, mitigation would not be appropriate. So there should be a but-for finding there wasn't here.
How
Yes.
would one show, in this case, that but for the addiction? How do you show that?
The medical testimony from treating psychologists or therapists would certainly be helpful, and that did not happen here.
Well, I assume you could show it by saying I had a, 200 or 300 a day cocaine habit, and I can tell you that my income was not sufficient during that period of time, and the only way I could support my cocaine habit was to take funds from, and I took them from my mother and my sister, and ultimately I took them from my client because I couldn't stop the habit.
That may be sufficient, Your Honor, but short of something like that and more preferably...
I mean, was there evidence in the record of what his drug addiction cost him?
No, there was not, Your Honor. He testified that he was using every day during this time period. Actually, the hearing committee found that he didn't start using every day until 2004. So there really wasn't any specific concrete testimony along those lines. Finally, we're asking the court to make a policy determination in this case that an addiction to illegal drugs should not in any event be considered as mitigating the sanction for intentional misuse under the chauffeur case. The bases of this argument are simply this. Lawyers have a special obligation to honor the rule of law, and also we are a self-regulated profession, and the court, the board, and the Bar Counsel's office all have an obligation to uphold the integrity of the bar and the integrity of the bar discipline process in the minds and the eyes of the public. And it would send a wrong message to the bar and the public to approve leniency for a lawyer who misused clients' funds as a result of an addiction to illegal drugs, especially in a case like this where the use was to purchase drugs for the lawyer's own use. And with that, I will rest unless there are any other questions.
Thank you, Mr. Marshall.
Thank you very much.
Mr. Rosenfeld?
Good morning, everyone. It's still morning.
Just.
What do you
Really?
say about Mr. Marshall's claim that the dissent case says presumptively if there's not full restitution, disbarment is the sanction?
Well, while the court says that in chauffeur it also makes a statement that when you can take into account other factors, as the court has always held since the matter of 3 attorneys in 1984, you look at each case individually and come to some conclusion about what that case deserves, not the fact that Bar Counsel wants to have only one form of discipline for taking clients' funds and not paying restitution doesn't really fit into the way the court's treated bar discipline up until this, certainly up until this time. I think what we have here is a situation where, and Mr. Marshall alluded to the fact that he's claiming that there's no causal relationship, or we haven't proven a causal relationship between the cocaine addiction and the conversion of client funds. In fact, the hearing committee stated that and they found credibility in the respondent, by the way, in almost every single instance, but they made a finding that his cocaine addiction contributed to his conversion of client funds. The board adopted that. The board also made the point very clearly that and I think this goes to the question that you asked, Justice Ireland, which is, and under what, how do you prove it? And what the board said is you can't do a scientific proof of causal relationship. What you're doing is you're looking at a person who's got some kind of a disability, including being a drug addict or being an alcoholic or whatever, and you can, because it wears down the moral fiber of that person, what happens is that it can be attributed to this. Now, what we're trying, the only point we're trying to make and have been right from the outset is that here's someone who in 2005, after he had stolen the money, after he had, I should say, converted the money and paid back some of it, but not all of it, recognized the fact that he had a major problem. It wasn't until then that he did so. Now, Mr. Marshall said, well, back in 2002, he was attending AA programs, he was conducting a law practice. His testimony included the fact that during that period, he was doing that so that it would appear, he was trying, but it would appear at least that he was trying to do something. He hadn't yet recognized at that point in time that he had a problem that he had to deal with himself. And until there's self-awareness, there's not going to be dealing with a problem like cocaine addiction.
Does the record reflect why he hasn't paid full restitution?
It isn't clear exactly. There's 2 points I would make that are in the record, at least. Point number 1 is he is a school teacher in the city of Boston. He's not being paid very much money. spends extra time coaching. He tries to work with the students. That's what he went and got his master's degree so he could teach. And he's very happy doing that, frankly. The second thing that I would point to the court is a letter, and it's on page 70 in the record, where a letter from counsel, myself and Mr. Marshall, responding to Justice Cowan's suggestion that why doesn't he start paying? And what our statement was, the Office of Bar Counsel informed counsel for the respondent it would not agree to the proposal of the single justice that the respondent pay the outstanding amount owed to the client at the rate of $100 per month, but instead proposed the respondent pay the outstanding amount within 30 days. He's got no ability to do that, to pay back that money.
Mr. Rosenfeld, what do you take of Mr. Marshall's policy question? And let me tell you how I hear it, right? There are all kinds of reasons why people start with legal substances like alcohol, and that just increases and increases and increases. But the first time that you imbibe or participate or use an illegal substance, you're not an addict, but there's the first time. Why should we not say alcohol is one thing, schizophrenia is another, mental illness is another, grief, distress, burdensomeness, stress, those are all different. Illegal drugs, this is a lawyer, you know you can't do it, you know, no mitigation.
Your Honor, I think that suggests that someone is voluntarily using drugs after
The
they
first time.
become an addict. Maybe the first time.
No, the first time.
Well, that's the same. That's also true in alcohol.
No, but that's legal.
Right.
I mean, assuming that they started it when they were...
It may be, but the fact is that that's what happens to people. I think we have to deal in reality here. And as this court...
No, I'm not suggesting that the addiction isn't serious. But Bar Counsel is saying, look, there's a difference between illegal conduct and inappropriate conduct, or conduct that does harm to your clients. You may have, for example, grief in the family. You didn't cause the grief. You didn't anticipate it. You probably should have sought help sooner. I mean, we've had cases where the grief was so overwhelming that it essentially immobilized people. They don't file papers.
This court has recognized that drugs, in the Knox case and in other cases, has recognized the fact that illegal use of drugs can be a basis to find mitigation on the part of a respondent. In Knox, it wasn't conversion of client funds, it was commission of a felony. And Knox received a 3-year suspension was imposed on Knox in that case. I think that what he's done here is demonstrated that he's been able to overcome that. He ought to be given some credit for that. The hearing committee felt that that was a special mitigating factor. The board felt that that was a special mitigating factor. And the single justice felt that that was a special mitigating factor. Now, I think that in Schofa, it doesn't say that when someone converts funds and doesn't pay them back, that there has to be disbarment. There is also language in Schofa that allows for taking into consideration when there's some kind of a mitigating factor. And that fits in with what this court has held, as I mentioned, since the matter of 3 attorneys and as late as in the matter of Slavitt, where each case should be decided on its own factors. That's what we're trying to make the argument here. And the factors here, I think, are compelling in terms of giving someone credit for overcoming what is a very, very difficult type of addiction. It took him a long time, but he actually did it himself. And I think the recognition that was given to him by both the hearing committee, the board, and the single justice should be recognized by this court. Now, this court,
Can I just interrupt you? Just to go back to the restitution. So what is happening about the money that he still owes his client? Nothing?
nothing. Well, he paid back 3,000 of it,
Right, but
and he
since
still
then, there's
owes
nothing.
the balance.
So how
And the
long-
balance is how much?
What's that?
3,600.
3,600 is the balance?
You know, that was what the discussion before the single justice was, is trying to come up with a
So we've got-
means to pay the balance.
Isn't
The-
the balance 3,600, though?
What's that?
Isn't the balance 3,600?
The amount.
Yeah, it is.
So why would the, I mean, Bar Counsel says X, he says I can't do X, I can only pay X minus $90. Bar Counsel says that's not good enough and nothing gets paid. Normally speaking, when one has an obligation to repay, somebody takes a look at the facts and orders you to repay, right?
Right.
I don't know how deep the record is on his current ability to repay, but regardless of what we do with his license, is there any reason why we shouldn't remand it back to the single justice to have a hearing and have a determination of how much he can afford to pay?
And that hasn't been done. Has not been that determination, other than the letter that I read.
No, I understand that there's a
saying that
disagreement.
he agreed, when I asked him to pay the $100 a month, he agreed to do that. I think it was the hearing committee suggested that while he should pay back the money now, particularly if he were ever to apply for reinstatement, obviously he couldn't be reinstated unless he paid the money.
No, I understand that. But meanwhile, I don't know what he's able to pay, and it's possible that that amount is zero at the moment, but it's possible that it's $10. It's possible, a week or a month. It's possible that it's 50, and it's possible that it's 100. What leaves me feeling uncomfortable is because you and Mr. Marshall, despite good efforts, I'm sure, and ethical efforts, couldn't reach an agreement. Your client shouldn't be not paying back money.
I'd be happy to try and reach an agreement with Mr. Marshall. We tried before.
No. But if you can't, isn't the normal solution that you have a hearing and a judge decides how much you can?
Right.
Your client may be saying to you, "I will not agree." Fine. Well, then a judge will.
We're perfectly willing to agree to that.
Yeah. Okay. Thank you, Mr. Rosenfeld.
Thank you.